Today, we're diving into a landmark Canadian Supreme Court case, R.V. Caslake. And trust me, it's a real head-scratcher of a legal puzzle that starts with a simple roadside discovery and ends up completely redefining the line between police power and our right to privacy. At the very center of this whole story is a question that sounds pretty simple. Can police search your car hours after you've already been arrested? I mean, you're in custody, your car's been towed. Seems like the answer should be easy, right? Well, that's exactly what the Supreme Court had to figure out, and the answer is anything but simple. All right, so let's set the scene. Our story kicks off on a highway just outside Gimli, Manitoba. It's one of those classic situations, the right person in the wrong place at the wrong time, and it sets off a chain of events with huge consequences. So here's how it all went down, and it happened fast. A conservation officer sees a car parked on the highway, and a man, Mr. Caslake, in the tall grass nearby. Seems a bit odd. A few minutes later, Caslake drives off, and the officer checks the spot. Bingo. He finds a garbage bag stuffed with 9 pounds of marijuana. The officer chases him down, pulls him over, and arrests him. Then the RCMP shows up. Constable Thomas Boyle takes custody of Mr. Caslake and gets the car towed. So far, so good, right? Seems like a pretty standard bust. But this is where the story takes a massive legal detour. You see, the arrest is done. The suspect is at the station. The car is locked up in an impound lot. The immediate danger, if there ever was one, is over. But the police work wasn't quite finished. 6 hours. That's how much time went by between Mr. Caslake's arrest on the side of the highway and when Constable Boyle finally got around to searching his car at the garage. Now, the delay itself is interesting, but what's really critical here is why he decided to search it after all that time. And this, right here, is the million-dollar detail. When he was put on the stand, Constable Boyle was totally upfront. He said he wasn't looking for more drugs, he wasn't looking for weapons. His one and only reason for the search was because RCMP policy said he had to inventory what was inside the car, for safekeeping. He wasn't even thinking about the investigation. Remember that. It is the detail this entire case hinges on. So during this supposedly routine inventory search, he found something that wasn't so routine. About $1,400 in cash and, more importantly, 2 little packages of cocaine. And boom, that discovery led to a whole new charge against Mr. Caslake for possession of cocaine. And it's that charge that kicked off a legal fight that went all the way to the top. So let's zoom out from the facts for a second, because this is where the case stops being about one man in his car and starts being about a fundamental clash of legal principles. We're talking about the balance between the power of the police and the rights of the individual. The absolute foundation here is Section 8 of the Canadian Charter of Rights and Freedoms. It's a huge deal. It guarantees every single one of us the right to be safe from unreasonable search or seizure. And the courts have been really clear on this. If the police conduct a search without getting a warrant first, that search is automatically considered unreasonable. The burden is then on the government to prove it was justified. Now, of course, there are exceptions, and one of the biggest and oldest ones is the power of search incident to arrest. It's an old common law rule that says when police make a lawful arrest, they can search the person in the area right around them without a warrant. It makes sense, right? They need to check for weapons, make sure the person can't escape, or find evidence of the crime they were just arrested for. It's a necessary exception to the rule. So now you see the conflict. This brings us right to the heart of the legal puzzle. Can a search that happens 6 hours late at a different location and for the sole purpose of following an inventory policy, can that really be called incident to the arrest? That's the question the Supreme Court had to answer. So what did the Supreme Court decide? Well, in a ruling that really clarified the law in a major way, they came back and said, nope. The search of Mr. Caslake's car was not legal. It violated his charter rights. And to get there, the court actually created a new 2-part test. They said it's not enough for a search to just look reasonable from the outside. The officer's actual state of mind, what they were thinking at the time, matters. The search has to be justified both subjectively in the officer's head and objectively in the circumstances. And this chart makes it super clear. On the left, you've got the valid legal reasons to do a search incident to arrest, protecting people, preserving evidence, or finding more evidence for the crime you arrested them for. But on the right, what was Constable Boyle's reason? Just following RCMP inventory policy. The officer's subjective purpose didn't line up with any of the legally accepted ones. And that's the whole ballgame. Because the reason in the officer's head was totally disconnected from the actual arrest for marijuana, the search failed that first part of the test. It wasn't really incident to arrest. And if it wasn't incident to arrest, then it was just a warrantless search with no legal excuse, which is a textbook violation of Mr. Caslake's Section 8 rights. But wait a minute. If the search was illegal, then the cocaine evidence gets tossed out, right? Case closed? Well, not so fast. This is where the story delivers its biggest surprise, and it's all thanks to a different part of the charter. You see, the charter also has Section 24(2), and it basically says that just because evidence was found by violating someone's rights, it doesn't automatically get excluded. A judge has to decide if admitting that evidence would make the justice system look bad. It forces the court to do a very careful balancing act. So the court looked at three main things. First, trial fairness. The cocaine was physical evidence. It existed on its own. It wasn't like a forced confession. So keeping it in didn't make the trial itself unfair. Second, how serious was the violation? The court decided it wasn't that serious. The officer wasn't being malicious. He was just acting in good faith, following a policy he thought was legitimate. And third, the reputation of the justice system. The court concluded that throwing out key evidence for a serious crime, all because of a good faith mistake, would actually hurt the public's perception of justice more than admitting it would. All three factors pointed to the same conclusion. The evidence stays. So in the end, Mr. Caslake was convicted on the cocaine charge. But the case he fought left behind a powerful and really complex legal precedent that lawyers and judges still argue about to this day. And what's wild is that even the Supreme Court justices themselves couldn't fully agree on why. The majority created that new subjective test, found the search was illegal, but decided to keep the evidence. But another group of judges chimed in saying, "We agree with the outcome, but for a completely different reason." They argued the officer's thoughts were totally irrelevant. For them, the search was objectively reasonable and therefore perfectly legal from the get-go. It just shows you how deep these legal weeds can get. So, what are the big takeaways from Caslake? First, it established that an officer's purpose really matters. They can't just go on a fishing expedition and call it an inventory search. It put police on notice that just having a policy doesn't make a search automatically legal. But it also sent a huge signal that courts won't throw out good evidence for every minor mistake, especially when police are acting in good faith. It's all about that balancing act. And that leaves us with the massive, ongoing question that this case puts right in our faces. In a free society, where exactly do we draw that line between our fundamental right to privacy and the very real need for police to be able to investigate crimes effectively? The Caslake decision is one of Canada's most important answers to that question, but the debate is far from over.